Hello, friends, and welcome to another WSIB Truth Matters with Joe Machado. I hope you're doing well. Today, I'm going to talk about an issue that you probably won't ever have to deal with, hopefully not, but it does happen, and that's the subject of recovery of benefit-related debts. It's covered under Policy 180104. And basically, it talks about every aspect of benefit-related debts, how they're created, the possibility of it being created, and the various situations under which it could be created, and of course, the WSIB's various strategies in how to correct it. When I had my paralegal firm, we dealt with a number of these over the last 30 years, and not a lot, but it does happen from time to time, and it does help if you know what to anticipate and how to deal with it. I find that dealing with the WSIB is much like trying to pin the tail on a donkey or hitting a piñata, and both of them blindfolded. You never really quite know where you're headed. So my goal with this channel is to provide you information that situations that my paralegal firm dealt with, what works, what doesn't, and to provide you with sufficient information that if it does happen to you, you're in the know. And that's important. So the policy that I'm going to be referring to is Policy 180104. And the policy talks extensively about benefit-related debts, how they're created, and the WSIB's various strategies to address it. So what is a benefit-related debt? So here's what the policy states. A benefit-related debt is any payment the worker made, the WSIB made to a worker, including an individual with optional insurance. That would be somebody who's in a self-employment situation. A survivor, a dependent, an employer, a Schedule I employer who has paid a worker advances on benefits under the insurance plan, an agency or any other person who receives monies that exceed entitlement under the insurance plan being the Workplace Safety and Insurance Act. It also covers the Workers' Compensation Act. The due date of the debt owing to the WSIB when it's created, the date the payment was made that should not have been made is considered the date from which the debt is due and owing to the WSIB. So this is the date that they would use to try and recover monies that were paid erroneously. The next section deals with situations when the WSIB pursues full recovery of the benefit-related debt. There are instances where the WSIB doesn't pursue recovery of the debt. I'm going to talk about that as well. But here's what the policy says with respect to when they do pursue benefit-related debts. So debt resulting from duplication of employment earnings and benefits under the insurance plan, so receiving both at the same time. And that does happen. It's happened with some of our clients. Failure to report a material change in circumstances, a fraud and or false or misleading statements or representation in connection with a claim for benefits or an attempt to obtain payment for goods or services provided to the WSIB, and or administrative errors when the debtor was aware or should reasonably have been aware of the error. So, if your loss of earnings benefit is $1,200 a month and you get a check for $5,000, that's what they're referring to there, that obviously you should be reasonably aware that it's probably an error. The next section deals with situations where the WSIB does not pursue a benefit-related debt. So in this regard, the policy states, when the debt is a result of a previously entitlement decision overturned due to reconsideration or appeal, the debt is a result of an administrative error, and the debtor could not have reasonably been aware of the error. The debtor is not notified of the debt within 3 years of the date the debt is considered due and owing to the WSIB, and or the WSIB determines that recovery action will result in severe long-term financial hardship. So those are the instances where the WSIB does not pursue recovery of the debt. The next section talks about 4 situations when recovery is pursued by the WSIB. So it gives you very specific situations where this happens. And in this regard, the policy states, number 1, duplication of earnings and benefits. This situation occurs when a worker is in receipt of earnings from employment and benefits from the WSIB for the same period of time. Duplication may occur when a worker deliberately gives incorrect return to work information or fails to report material change, for example, a post-accident wage increase that should be reported, but may also occur unintentionally. For example, if benefits are paid in advance, a debt may result if a worker returns to work sooner than originally expected. I haven't really seen a lot of that. If anything, they don't pay on time, not in advance. The second point here is a material change in circumstances. This is a very important one. I'm pretty sure you've already received some kind of a letter with respect to this material change in circumstances. A material change in circumstances is any change which affects an individual's entitlement to benefits and services under the insurance plan being the Workers' Compensation Act or the Workplace Safety and Insurance Act. A person who's receiving benefits or who may be entitled to receive benefits under the insurance plan must notify the WSIB of a material change in circumstances within 10 days after the change occurs. The third and fourth situations where the WSIB will pursue recovery of the debt are number 3, fraud and or false or misleading statements or representation. So any information or action which in the WSIB's opinion constitutes a willful attempt to obtain benefits, payments, or services to which an individual is not entitled is considered fraud or misrepresentation. This includes but is not limited to providing false statements, fitness to work information, and or misleading forged accident or other reports. Number 4, the debtor aware of administrative error. The WSIB pursues recovery action when a debt results from an administrative error and the debtor knew or reasonably should have known that the payment exceeded entitlement. Administrative errors include systems, human and mathematical errors or miscalculations. Again, those seem to be pretty straightforward. So the next section, I'm going to talk about 4 situations when the WSIB does not pursue recovery of the debt. So number 1, previous decision overturned. The WSIB may change a previous decision on reconsideration or appeal if it is apparent that the original decision is not consistent with legislation or approved policy or new evidence changes the decision. The WSIB does not pursue debts resulting from reversed or amended decisions unless there's evidence of fraud and or false or misleading statements or representation in connection with the claim for benefits or an attempt to obtain payment for goods or services provided to the WSIB or failure to report material change. Again, pretty straightforward. The number 2 of these 4 situations is debtor not aware of an administrative error. A debt may result from a miscalculation and mathematical errors, authorizing and issuing duplicate payments, and or inaccurate data entry. Debts resulting from administrative error will not be pursued if the debtor could not have reasonably been aware of the error. If an error is discovered, any future payments in the claim will be used using the correct rate. So yes, and I've seen this happen as well, where for some reason they didn't enter the proper earnings information, benefits are paid, it's miscalculated. It's more than what it should be. And it's really difficult for a claimant to know how the calculation is made, unless you're a WSIB expert. And so it's something that does happen, and the person may not be aware of it. And so the WSIB doesn't pursue recovery of the debt. But what they do is they will correct the calculation, and on a going forward basis, they will use the correct number. So situations 3 and 4, where the WSIB will not pursue a benefit-related debt, are as follows. The 3-year rule. To pursue recovery, the WSIB must notify the debtor in writing of the debt within 3 years of the date of the debt is considered due and owing, unless the debt results from fraud and or false or misleading statements or representation in connection with a claim for benefits or an attempt to obtain payment for goods or services provided to the WSIB, or failure to notify the WSIB of a material change in circumstances. So they must notify you within 3 years. If that doesn't happen, they won't pursue the debt recovery. And the fourth one being financial hardship. If a debt exists, but the debtor has provided the WSIB with sufficient documentation for the WSIB to determine that recovery action will result in financial hardship, the WSIB may eliminate the debt in whole or in part, unless the debt results from fraud and or false or misleading statements or representation in connection with the claim for benefits or an attempt to obtain payment for goods or services provided to the WSIB. So in these 4 situations, the WSIB will not pursue the recovery of the debt. They do get into what they would consider financial hardship and how they come to that determination. And so basically in that regard, the policy states, temporary financial hardship. Temporary inability to repay a debt does not constitute financial hardship. These situations are addressed by flexible recovery methods. And what they mean by that is there can be an arrangement between the person, the debtor who received the money, and the WSIB collections department to repay that money. And generally, that will suffice. And in my experience, they prefer to do that whenever possible. Sometimes it's not. And so the next portion here, titled Severe Long-Term Financial Hardship. So in cases of severe long-term financial hardship, the WSIB may exercise its discretion to reduce or eliminate the debt if failure to do so compromises the debtor's ability to maintain the necessities of life, for example, food, shelter, or transportation to work. The WSIB will pursue recovery action until the debtor has provided the documentation necessary and the WSIB has made a determination regarding long-term financial hardship. And so there's quite a bit of information that the WSIB will require in order to make a determination that if pursuing the debt will produce severe long-term financial hardship. And that information is explained in the policy. So the policy states, factors considered when determining severe long-term financial hardship include, but are not limited to, the debtor's employment status. So if you're not employed, that could be helpful. Employment security, clinical restrictions, which may prevent the debtor from increasing employment earnings, opportunities for reemployment if not currently employed, earning capacity, personal and vocational characteristics. The debtor's level of education may have an impact on earning capacity. Assets, automobile, property, home, current source of income, welfare, employment insurance benefits, WSIB benefits, CPP or QPP benefits, pensions, rental property income, investments. So they look at all of that. Current expenses, for example, rent, mortgage payments, car payments, family support, childcare. They also look for available statements from the financial/credit counseling agency and whether the debtor has declared bankruptcy, is in the course of bankruptcy proceedings, or has had a discharge in personal bankruptcy. So they are pretty thorough, even though they are accommodating, and I've seen this happen in the past. They're pretty thorough in making a determination as to whether making recovery efforts to collect that benefit-related debt will be pursued. And so if you're in this situation, you want to provide as much information as you can to allow them to make that determination. So these are the several other methods available to the WSIB to recover benefit-related debts. And there are a few. As I said, they do and will work with you, as you're going to see from the policy here. But they do have a few that they can use to recover benefit-related debts. So in this regard, the policy states a voluntary repayment plan. The WSIB generally prefers to negotiate repayment arrangements with the debtor. Full or phased repayment can be made through personal funds or through deductions from WSIB benefits, payments, or rebates. And I've seen that happen. As I said, they will work with you to try and collect that debt, but without having to put too much financial strain on yourself and your family. The other one is offset from future payments. So the Workers' Compensation Act and the Workplace Safety and Insurance Act gives the WSIB the power to offset the debt through deductions from any money payable to the debtor by the WSIB. Therefore, the WSIB can offset a debt from a worker's benefit payments. One example is if you're receiving loss of earnings benefits and you owe money to the WSIB, if there was an error in calculations, they can negotiate a portion of that to be offset, meaning if you're receiving $1,200 a month, you could receive $1,000 or you could receive $700, whatever is agreed upon to offset from those benefits. So it's not coming out of your pocket, but it is coming from the benefits that are payable to you. And then the third one here is recovery from periodic payments. And it's a pretty similar one. For the purposes of this policy, periodic payments include temporary total disability benefits and temporary partial disability benefits. This deals with pre-1990 claims. Loss of earnings benefits, non-economic loss benefits if paid in monthly. Future economic loss benefits, payments for loss of retirement income, healthcare expense reimbursement, and any other payments made to the debtor. So if you're receiving any one of those periodic payments, the debt could be reduced from them. There's two other situations here, which is deduction from lump sum payments. Full recovery of debts through deduction from lump sum payments is pursued, unless doing so would threaten the debtor's ability to maintain their residence, perform work, or maintain a livelihood. So they could deduct it from, if, for example, a nil lump sum payment or arrears benefits that would result in a bulk payment or a lump sum payment. They could deduct it from that as well. The debtor cannot initiate a commutation to recover a debt. However, if the commutation is being processed, the WSIB can recover any debt that is due and owing from the lump sum payment, unless doing so would threaten the debtor's ability to maintain their residence, perform work, or maintain a livelihood. So a lump sum payment would be commutation from a pension, pre-1990 pension. So if you're receiving a pension, let's say 20% paid monthly, and you wanted to commute that all or part of that pension, and you meet the criteria for the commutation. I believe I did a video about commutations a few videos back. Then the portion of the debt or the debt could be recovered through that lump sum payment. And the last one here, recovery of debt through a court action. And so where appropriate, in the WSIB's view, proceedings could be initiated to recover debt through the courts. And I have seen this that happen in the past with clients. Very rare that the WSIB will take that step if any of the other situations or processes could be used. So I always suggest be cooperative with the WSIB, with the collections department, and try to arrange a repayment plan that is agreeable to both parties. It's always the best scenario. The policy also covers the following situations. Situations such as personal bankruptcy. So if you're involved in personal bankruptcy, there are certain strategies that could be used to recover the debt, and recovery from the estate of or survivor's benefits. So there are some guidelines as far as that's concerned. Haven't seen these happen very often, but the policy also does cover those. And when the WSIB makes a determination that they're not able to recover the debt, so that at the present time it's not feasible to recover that debt, what the WSIB does is make a note on the file of the debt that's owing, and they can recover the debt from future benefits being paid out in the claim or benefits being paid in another claim. So they could use those benefits to recover that debt, or debt. So they will have a note of that to deal with it at that point in time. And so the last portion of the recovery of a benefit-related debt section is debt decisions and appeal rights. So the policy states, as a result of changes in the Workers' Compensation Act, effective December 14, 1995, the date of royal assent of Bill 15, the debtor's objection appeal rights concerning the determination that a debt exists, the amount of a debt, or any issues related to debt recovery differ according to the date of the payment that is subsequently determined to be a debt due and owing to the WSIB. So in other words, when it's determined that there is a debt owing, there are three instances with respect to the decision by the WSIB as to whether or not those decisions are appealable. So for debts resulting from payments made before December 14, 1995, debtors have the right to appeal debt decisions, both internally at the WSIB's appeals branch and externally at the Workplace Safety and Insurance Appeals Tribunal. For decisions on or after December 14, 1995 through December 31st, 1996 inclusive, debtors may only appeal the debt decisions internally at the Workplace Safety and Insurance Appeals Branch. And for those on or after January 1st, 1997, debtors do not have any internal or external appeal rights. So for that time frame onward, the decision is not appealable, according to WSIB. Suspension of recovery during objection or appeal. So if you object to a decision, specifically decisions for payments before December 31st, 1996, the WSIB will suspend debt recovery action throughout the objection and appeal process. For the other two date situations, those payment recovery will continue to be pursued. So that pretty much covers the issue of benefits-related debts. Again, hopefully you won't find yourself in this situation ever. It could be stressful, and God knows you don't need that, especially when you're dealing with an injury and the effects of an injury. So, but it's good to have the information in the event that you need it. You can always refer back to this video. I do encourage you to read the policy if you find yourself in this situation. There are a few more things in the policy that I didn't cover specifically in this video, although I did cover most of it. But if you have any questions about any of it, by all means, send me an email at joemachado@wsibsettlements.com and give me the specifics of your situation, and I will get back to you and give you some direction or guidance as to how to handle it. So this pretty much concludes this section of this very boring and dry subject. Coming up next, it's my third episode of the Focus on WSIB segment that I've added to the channel. It's a once a week video that exclusively deals with the Workplace Safety and Insurance Appeals Tribunal. And I would urge you to go and view the video that I posted, I think 3 or 4 videos back when I launched this segment, so you have an understanding of why I'm doing it. And I think it's very important to do that. I believe that the Workplace Safety and Insurance Appeals Tribunal is the best bet for injured workers to have justice in their cases. I have no faith in the Workplace Safety and Insurance Board at all, whatsoever. And I think that everything they do is a detriment to injured workers for the most part. I believe that their attack on injured workers and injured workers' rights have been increasing significantly over the last 10 years. And I'm sure that a lot of you have already felt this. And it's a serious, serious issue that's being discussed not only by myself, but many other individuals or groups that provide support for injured workers. This is the second episode that I'm going to be covering the Whistleblowers Report, titled Prescriptions Overruled. This report was put together and it was released by 2 organizations that provide assistance to injured workers, 2 amazing organizations, the Ontario Federation of Labour and the Ontario Network of Injured Workers Groups. They've been around for a long time, and they do provide a lot of useful information and bring to the surface a lot of issues that injured workers and their families are dealing with that are pretty much resulting from actions of the WSIB. And so I think it's important to cover this report. So last week I did my first episode, and I talked about the problems and the many issues that were noted by these organizations in their report that were affecting injured workers in a significantly detrimental manner. And so this episode, I'm going to talk about some of the solutions that were noted in their report and go over what they were and whether or not there's been much done in terms of the WSIB to make things better for injured workers. So that is going to be my next video coming out on Wednesday. Once again, friends, thank you for taking the time to watch this video. I want to thank my subscribers for sharing my videos and helping me to build this channel. It's a big goal of mine. I want to be able to reach every injured worker in this province, to make them aware that there are tools and support to help them with their WSIB claims, that they're not alone. I have over 30 years of experience dealing with the WSIB exclusively and with the Workplace Safety and Insurance Appeals Tribunal. With my paralegal firm, we dealt with pretty much every scenario that could come up in a claim. And both myself and paralegals working for me over the years, we have a lot of experience that I want to be able to impart. And I've decided to use this YouTube channel as a medium to do that. It's free to become a subscriber with my channel, and all the information I provide on this channel is free. I've got over 30 years of videos that I'm going to be continuing to do over the next few years. to provide all of this information to help injured workers. That's my biggest motivation. I also have WSIBsettlements.com, which is my company, and I developed a number of tools and support systems based on tools that have been used over many years that work to help injured workers with their claims. And our members are using those tools, and it's helping them to succeed in their claims. So if you haven't been on our site, please visit the site. It's WSIBsettlements.com and see if there's something there that you can use that's useful. If not, that's fine. I mean, you can continue to watch the videos. They're free. And I do offer a lot of tips on how to address certain situations. And I also welcome you to become a subscriber of the channel. All right, friends, thank you for taking the time to watch this video. Look forward to presenting the next video to you. And as always, take care.